For the people, cannot take them back.
Please give it to the court master.
I have also same there.
Give it to the court master.
No, please, Your Lordship. Item number 18 may kindly be taken as an updated matter, Your Lordship. This is 80 years of well, Your Lordship. Earlier occasion got listed, Your Lordship. Your Lordship, item number 18, Your Lord.
We will try to. It's a 2025 matter.
Yes.
We'll try to.
Lord. Be obliged.
May I please, your lordships? My lord, item number 12 and 13, my lord. Lord, may not be, my lord. May not be, my lord.
I think 12 and 13. Both sides are represented. Let this matter be listed without one of us. Going back. I must go. J.
Obliged.
Please, the Lordship. Lordship, I beg to mention item number 10, my lord. And this matter may kindly pass over for 2 weeks, my lord.
Other matters where there is no circulation of advance notice, we are not adjourning it. We'll have to wait. On Tuesdays and Thursdays, please make it a point to inform us in advance. We have some difficulty because on these 2 days, we are listing very less matters.
With your applause.
May I please, Your Lordship? Take the concern with Dharak side. I beg to mention item number 6, Lordship.
Same thing.
Supplementary list, item 19 for motion.
Lordship, we have received the instructions.
May I do, Lordship?
Mr.
Yes, Islam, Lordship.
S. Islam and counsel for the petitioner, as well as for the respondents of the next paragraph. Pursuant to order dated 28/7/2025. The Learned Standing Counsel for the FT matters has produced a copy of written instructions dated 30/7/2025. Received from the Senior Superintendent of Police within bracket border, bracket close, Assam. Sorry, Guwahati. No, this is not Guwahati. From the Superintendent Dorong Mongolday. Informing that Sahamat, Sahamat, Sahamat Ali, sorry, Sahamat Hussain. Bracket 65 years. Son of Hussain Ali. Is presently kept at the holding center, 7th Assam Police Battalion, Saraikula, Kokrajhar. Next, accordingly. The court is inclined to direct the superintendent of this holding center. The superintendent, right?
Yes, Lordship.
Superintendent of this-
SP, Senior Superintendent of Police has.
No. The holding center will be in charge or it will be in charge or superintendent? I hope.
Deputy Superintendent of Police, come IC Holding Center, Lordship, the next page.
Next page below, Lordship, yours faithfully, below it's written. 7th APBN,
The the Deputy Superintendent of Police, Winnipeg, Border, come in charge, holding center, 7th Assam Police Battalion, Kamacharai, Koprasar, to allow the petitioner, namely Mohibul Islam, and one family member to visit the detained foreign national and to take his signature in the Vakaratama to be authenticated by the state authority. Let's talk, give a date after 2 weeks. By producing a certified copy of the order.
Lordship, Lordship, kindly allow 3 persons from family member for this.
No 3 persons. We are not celebrating anything. One person is the petitioner and one more person. You have a choice between them.
And my lord, there is another development in this matter, my lord. Even I have received some instructions, my lord. My lord, the person was handed over to us, the BSA, my lord. The BSA, my lord, sent him back on the independent night of 26th, 27th of May, 2025. On the next day, my lord, returned back. Then thereafter, my lord, he was handed over to them,
pushed back,
sent back.
sent back.
Okay.
That instruction you can give,
Yes.
he'll give a copy, Lordship, he
Yes,
has it.
It's on the way, my lord. I'll get it.
We'll get it in course of the day.
My lord.
Okay, then we make a note and after that
Yes,
we make the
yes,
changes
yes.
required. Or rather we say, at this juncture, the learned CGC has submitted that as per verbal instructions received by him, the said detained foreign national was handed over to the BSF for being sent back to the to the specified territory, which was done during the intervening night of
26th, 27th.
26th and 27th of July 2025. So, however, the said person was again found in the territory of the country, and therefore he was apprehended and again handed over to the state police.
My lord.
So he placed for some time to produce the written instructions. Let the said instruction be produced on the next day. This all,
I can produce it today itself.
it's okay.
He has it on his phone, he
Yes.
just needs to send it to the court master, Lordship.
Okay, then do it. Okay. Let's produce the copy thereof. Which is made a part of it. Okay. Let's check it out.
मैं भाभी को अपना सब हमसे कॉपी लेने में लगा कर कर दी थी। मेरा अपना तो कब तक पूरी कॉपी को। इसलिए मुझे भी बात को
Ms. Verma, you have the petition.
Yes, Lordship.
At page 2, he says his father-in-law is 57 years. The person you are holding is 65 years. 8 years is not a,
Lordship, what age he has stated there, Lordship, how we will
That is what-
know.
I think you need to produce some evidence that 57 years old person is your father-in-law. They are holding someone with 65 years. Is he the same man?
It is his,
It has to be identified first before you
Yes,
can go and meet and get some protection.
where has he given his age? No, it's son-in-law. Lordship, where did you find the age, Lordship?
Page 2,
No, of my instruction.
yes, name
Yeah.
the DFN Sahamat Ali 65 years.
Yes, but in the petition, Lordship?
Page 2,
Into court title.
first title,
Yes,
illegal detention of the petitioner's father-in-law, namely Shahamat Ali, aged 57 years.
That means they must have made a mistake, Lordship.
Kind of. The entire issue here is of the identity of the person, whether he is the person who is a detained person or not, or a declared foreign national.
Lordship, these petitions are mostly made on those lines, keeping lot of gray areas, Lordship.
Even when you go to the judgment by which you were, the person was declared a foreigner, it was all based on age. The age was not mixing, the age was not matching up. Now again, there is a discrepancy. Don't have your instructions on that.
Lordship,
If there's a mistake, have it corrected.
Lordship,
Proper person, how you got.
Lordship, one age correction will not help, because in the voters list, there would be, this is, we can choose document, Lordship,
Person
to,
he talks about to be his father-in-law, if
Yes.
he says he's a 65-year-old man, then this is the man you are holding.
yes,
If he
Lordship.
says he's 57, you're holding
Then
the
this
wrong
may
man.
not be the man.
No, no, no. You see, it's not a very simple statement we are making. My esteemed brother is saying that before he goes and meets a person, he must satisfy that it's the same person and then meet,
Yes.
because If-
I,
if both ways.
and Lordship has also understood what I'm trying to tell Lordship, that all these documents are mix and match, whichever has suited, that has come. So that is the reason we have
times-
so many alliances, Lordship.
Ms. Verma, at times you're very hard of hearing. Many things we can't hear.
Lordship, I will also adopt that procedure now.
Lordship, we will verify and qualify.
Yes, well, Lordship may take up this matter tomorrow.
No, 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 no.
You
You're not
verify,
doing
madam.
it, but you're trying to find out something.
Lordship, if Lordship wants, we can get a picture of him, Lordship.
No, no, no. We don't need that.
Oh, okay. या तो टाइप कोई बोल रही थी तो वो तो ये टाइप हो गया लगता है बस तीनों कितनी लगती है
Lordship is
Because the petitioner is,
son-in-law.
no, he's referring to a very future, he's having a very futuristic approach. We come to page 24.
Yes, Lordship.
He was admitted to the central jail cum detention center on 4/3/30/29.
sorry, Lordship.
It's okay. You're not doubting it, but we are,
Typing in mistake, Lordship.
you had yesterday, that day you produced a copy of the writ petition. Do you have a copy of that writ petition?
Lordship,
The writ petition filed earlier. Do
yeah,
you have a copy of that?
Lordship. Yes, Lordship, yes.
Please, pass it on.
Lordship, we just have some information. This matters may be kept timing. AG will appear, Lordship.
Yes, Lordship.
Yes.
Okay.
Lordship, the next 4 matters, Lordship.
Okay. Wait for some time.
Lordship.
He is appearing. Ah,
Lordship, just for Lordship's information, Lordship, 20 to 23, Lordship. We have been made parties, but no copies have been served to us in the initial stage also, and even after Lordship's order, no
Item,
copy was served. 20, 21, 22, and 23.
then we will have to adjourn it for 1 week.
And
Mr.
Lordship,
Mr. Ahmed,
We have no
You
instruction.
have saved some money. You have saved some money.
No, my lord, I have already served.
Lordship, we check the records. Our
He
names
served
are
copy
there,
to him.
not to us. Our names are there. We are respondents, but no copies served to us.
1 week. We
Prior
told
to
you on that day to
filing-
give extra copies.
Prior to
You please
the
check the
copy-
records. I am talking from records.
Not I will serve.
We'll goes
And
by
no
1 week.
extra copy also, no.
Copies, 22. Yep.
My understanding was that I have to serve only one.
No, don't have
copy.
impressions.
No,
In these matters like this, when we are fixing a matter, in a
Today
day,
itself,
two
I will
times.
serve the copy.
Specific direction. In the meanwhile, the learned counsel of the petition shall one copy to CGC as well as to the standing counsel for FT matters, along with one soft copy. Very specific order. In all these items, series, item 20, 21, 22, 23,
23.
are separate orders.
Lordship, AG is coming for these matters only since we don't have a copy. I just informed the board. He's coming for 19 to 23.
Okay. Okay. Accept.
আমাক তো আপনি এটা কপিও দিয়া নাই, আপনি দুটা কপি আমাক দিয়ক। তাক তাতে কাম করতে। এটা আপনার তো বেতন দিতে এসেছি না হচ্ছে। 20% দেখেন আপনি কপি জানেন।
Daily list item 1 with 2 for admission.
Yes, sir. Thank you, one more expert here.
Yes, Lordship. It's a very old matter, Lordship. And he approached this court once he was arrested on 7/8/2024, Lordship. And when he was there in the detention thereafter, through legal aid, this matter was assigned to me, Lordship. So exact reason, even the son, I asked the son why he did not appear before the learned tribunal when the notice was issued to him. He said that I don't know the reason behind why he couldn't appear, Lordship. And if I have. Yes, Lordship. Yes, Lordship. Lordship, I have checked the records because as per the impugn order, 3 persons are declared as an illegal migrant. 3%, and the reference is only against the present petitioner, not against the other petitioner's lordship. That we can rely upon lordship as per this Honorable High Court's order, Sudhir Roy versus Union of India, as well as Basanti Biswas versus Union of India and others. In both these two judgments can be relied, and the other persons can be relieved from this matter if the reference is only against the petitioner. At this stage, lordship, I'll humbly pay whatever reasons might be, lordship. At least I'll humbly beg before this court, lordship, at least one chance, lordship, because he has all the relevant documents. In fact, lordship, as a legal aid counsel, I'll assist him to draft his even written statement, lordship, and let him, if lordship doesn't allow him to be released from the detention from the time being, but at least if he, through his son, if he can file his written statement, at least he has genuine documents, lordship. Whatever reasons might be, he couldn't appear before the Larned Tribunal earlier, lordship. So I humbly beg lordship before this honorable court, at least I have annexed the documents, lordship. If lordship would like to peruse all these documents.
Because the first hurdle has to be processed. The IMDT opinion is of 31/7/1991.
Yes, lordship, that I do admit. It's a very old matter, lordship. At that situation, what was the circumstances for which reason he couldn't appear before the Larned Tribunal, lordship? Just to forgive him for his misdeed, what he has done, lordship. But at least giving him a fair chance just to prove it,
We have
citizen.
only to decide, forgive is something which the state will have to do.
At least
Yeah.
one chance, lordship. I'll humbly pray at least one chance, lordship. If it would have been contested matter, I wouldn't have argued so much, lordship, since I'm only praying since it's an ex parte and he has good documents, lordship. Documents are there, lordship, and there is no shifting also. Even to prove that also won't be much difficult, lordship.
No, that's not everything. The reason is that he was declared to be a devoter. That means he lost his right of franchise way back in the long back.
Yes, maybe from 97, lordship.
You don't know. You're not really sure, but
Yes,
once he has
lordship.
been declared to be a devoter, he remains with that status. So therefore, it is too late in the day to say, even for a person who is claiming legal aid, for that person to show that all these years he couldn't appear before the court, challenge it.
Once he appeared
a-
before
it's a
this
case of
honorable
devoter.
court, lordship,
Because it-
just to make a reference against him. Thereafter also, it's not known what was thereafter what happened, lordship.
Ms. Baba, can we have a look at the record, please?
Lordship, records even show that we had approached this High Court in 92, and it was dismissed, Lordship. Page,
No, no, there's something else we wanted to see, not that. Something else we wanted to see.
I'll send it across, yeah.
Send it back. Wanted to see something.
Is the reason for the matter. Let's take it. No.
This, Verma and Ms. Ghosh. Now, we have a situation here. You have already read the 1992 judgment
Yes, sir.
of this court. You have read that. The reference made was against that an appeal was filed against the appellate order writ petition, and the writ petition was dismissed. Now please come to page 23
Of the repetition.
of the writ petition.
Yes, Lordship.
Now, in this case, what happened was he was declared to be a D voter.
Yes.
Against D voter, he filed this writ petition, and this writ petition, this court ordered that let a reference be made. Now that this order is a unimplementable order because of the fact that when the IMDT has declared him to be a foreigner, his name will never be entered in the, that's a legal proposition that his name will be not entered in the voters list, but still his name appeared somehow. And he was declared to be a D voter, and this order was come. Now, the second reference referred to here at page 24.
The,
Here there's a direction that a reference be made by the Superintendent of Police.
yes.
That is an unimplementable order because of the fact that there's already a reference and it's been decided. There cannot be a second reference against the same man.
Same person.
Despite the order of this court, it will not be an implementable order. Now, we need an information whether as to, in view of this, whether any communication was made.
91 order,
No, page 23.
20.
How did
Just
the,
as.
how did the state take steps? And this is Ghosh, so far as you are concerned,
Yes, Lordship.
you are again in a very tight spot because of the fact that you look at this order, you may not be aware of it.
Appeal order.
Against IMDT,
IMDT appeal.
an appeal was also dismissed, a writ petition was dismissed. Therefore, this could otherwise not be maintainable. You have just a small lifeline,
This,
only of 1 or 2 weeks by the time they get instructions about that, but that relates to D voter. Doesn't help you much. So once this writ petition has decided, we possibly can't take it up. A challenge to the IMDT
understood
order
that-
would not be
that-
maintainable.
yes,
And then this-
because this aspect was not known to me.
That's why,
Yeah,
that's why
and-
we wanted to, once you said that we don't know, we
Hmm.
just wanted to see what had happened.
Yes, Lordship.
And therefore,
Then for me to get the order copy and then review may be one option. Yes, let me see how I can help this poor man. Otherwise, I will pray that let him be in detention. I will file
it
written.
can't happen. We can't touch it now.
Understood, since that order is there.
Lordship, another thing, maybe because she didn't know, this writ petition has no information about the previous
No, that's
proceedings.
okay. She's a legal aid counsel. You see,
Yes.
she'll
Limited.
depend on whatever instructions has been given to
Yes.
her. This man is in detention. His son says that he doesn't know the facts. So we excuse her for that. But the issue about this reference being made in this page 24.
But the petitioner knows, Lordship, he was arrested only in 24. He knew he had a proceeding against him.
No, we understand. You see, there's no difficulty. When
They have come, Lordship, my
when we could-
thing is
when-
the conduct of the petitioner, 91,
Miss,
he was declared foreigner,
Miss,
92, this
when-
dismissed.
you have seen us handling the trial court record.
Yes, Lordship.
It's only a minute of face that we understood everything. So it is not that we are oblivious of what you're saying. But the fact is, when once there is a judicial order, you just need to have a record straight as to what happened here. It may not help the petitioner, but still to keep a record straight, we must know what has happened.
So Lordship, what Lordship wants me to obtain Lordship, what instructions we need to.
We will give you a direction, either you'll have to tell us, you see, please come to page 24. It says directing the Superintendent of Police, last was 7, 8, 10 lines,
Yes, Lordship.
correct? Now, this is the direction. So to enable you to get instructions, do we give the direction to the Superintendent of Police or to the Home and Political B Department?
To make a reference of the other persons. It says
No,
that
no, no.
Lordship
Then
of the
you're
same,
not followed. Please come to the record again.
this one.
Yes, yes. There also the road of Mrs. Ghosh is closed. Now you see, read this order.
High Court's order.
I got order. Read
Yes,
this.
Lordship.
The last part of this page is the reference. No, first page. There was a reference against 3 persons
Yes,
and all these writ petitions were dismissed. This writ petition dismissed and therefore a reference to the family members has been upheld.
we'll get it.
You got it? This is also for you because this is something which has come here which we are not aware of. You can just write down the case number, you will get the,
I'll get the foot.
uh,
To the rule 96649. Yeah. 966, 1999. Actually, वो ये हमारी पुलिस है 31 मार्च 1997 फोटो कुछ ना था पिक्चर होता है पहले के या 97
But this is legal, legal aid counsel for the petitioner. Also, you get the name of the respondent, sir. This is as well. Next paragraph. Pursuant to the order passed earlier. Earlier in WPC 7746 of 2019. This record has come in 7746.
in 3098 lordship.
Yes, records has come in lordship in 7746.
Mayor already.
Comma, the
774.
relevant records of the tribunal is available. In this set, in connection with this set petition.
Their brothers, family.
On a perusal of the said record, it is seen that against the impugned opinion dated 31/7/1991, passed by the erstwhile IM within bracket T, bracket close T, Porpeta, in case number 38/98,
90 lordship,
90, okay.
90.
90. The reference was answered in the affirmative and the second parties in the said reference, comma, being for number one, Mohammed MD, Jakir, Jaker Hussain, comma, number two, Meheruddin, Meheruddin, comma, number three, Janu, Janu, next word, Hanu, Bhanu. Were held to be illegal migrants as defined in section 3 within bracket Roman 1 within bracket small c of the usable name, illegal migrants within bracket determination by tribunals, bracket 2, Act, comma, 1980. It was 83 or 84? In fact, I am BT Act. 83.
83.
Full stop. It also appears that an appeal was preferred against the said opinion, which was dismissed. And the said appellate order, Ms. Parna, what is
Yes.
that appellate order was challenged on the
Appellate-
first page of that?
That is civil rule.
No, appellate order. There's a reference to appellate order, first page. In that high court order, first page.
That is 12/1/2021, WPC 7746.
The appellate order is referred there. This writ petition is against which order?
This petition is against that 91,
This one, this one.
that is tribunal case number 38/90.
This 20. This will have an appellate order. There's a reference to appellate order here.
Before the tribunal.
Send this record.
The High Court ordered to serve civil rule appeal 170/90, date of order is
21/3/92.
Appellate order dated
21/3/92.
92, comma, passed
Appeal
In-
case number.
appeal.
170,
No, just say appeal
appeal case number 170/91.
91, comma, civil rule number
Civil rule number is
166.
966/1992.
was preferred by the petitioner, comma, which was dismissed by order dated
31/3.
31st March
97.
1997.
full stop. Next, by in light of above, the question to be considered by the court is as to whether the present writ petition would be maintainable. Next para. However, comma, the petitioner has annexed a copy of order dated 5/6/2015, comma, passed by this court in WPC 3263 of 2015, arising out of grievance of the petitioner of his name being included as the voter in the voters list of 1997. And this court by order dated 5/6/2015, directed the disposed of the writ petition by directing the superintendent of police within bracket border, bracket to Bopeta, to make a reference to the foreigners tribunal to adjudicate as to whether the petitioner is a foreigner or an Indian citizen. Next para. Accordingly, another question for determination would arise that if the petitioner has already been declared to be a foreign national by order dated, by opinion dated 31/7/1991, by the IM within bracket D, bracket close T, Borpeta in case number 38 of 1998. Whether another reference could, can be validly made. As the principles of res judicata may apply in the present case in hand. Next para, be that as it may, the learned standing counsel for the FT matters shall obtain instructions from the superintendent of police within bracket border, bracket Borpeta, as to whether any reference was made against the petitioner, namely, Jakir Ali, JAKER, alias Jakir, JAKER, Jakir Hussain, alias Jakir, JAKIR Hussain. Next part. The learned standing counsel for the FT matters is permitted to send a downloaded copy of this order to the said authority to obtain instructions. Next para, list on how much time? 10 days?
10 days. Lordship, this WPC may also be tagged with it. What grounds were taken for this order to be passed?
We'll have it.
Yes, Lordship.
We'll have it.
10 days, Lordship.
Please, give a date, please.
And
Give a date.
Lordship, 10th of August, no, 10th of August is Sunday, 11th would be fine, Lordship.
11/8/2025. Before that, list on so, before that is wait. The registry shall tag the records of WPC 3263 of 2015,
15, Lordship.
decided by order dated 5/6/2015. That is not decided, as well as records of civil rule number
Civil rule number.
Civil rule 966, 1992 of 1992.
22, disposed of by order dated
Order dated 31/3/1997.
1987. List on. And there is connected IA and WPC 7746 of 2019. Here is a outside the representative. This on 11/8/2025 along with WPC 3098 of
Other, can we hold the records for the day, Lordship? We would like to go through them.
just before that, you would say on a request made by the land standing counsel for the FT matters, court permits the standing counsel for the FT matters to retain the custody of
Mr. Pang, Lordship.
Mr. Pang, okay,
Yes.
Mr. J. Pang, who will retain the records of the tribunal for perusal and to address the court of the next terms.
Lordship, I'm appearing only in item 1, but item 2. So if Lordship allows me, I can appear in item
No,
2.
we
But
just can't do
yes,
that.
but since that matter is just I please, no one
No,
appear.
we are only saying list along with so-and-so. We are not recording presence, then don't record presence state people.
In that case also, I think it's filed too legally.
Whatever we get,
Yes,
see.
yes. Deeply.
Ito, extra copy with that.
Mr. Sharma and Mr. Sharma, there are 2 records with you. Please hand it over to Courtmaster because he is accountable. Till you
Check.
that records with you. Yeah. Please give it to the Courtmaster because he is otherwise accountable. He has questions to answer. Yes, bro.
Yes, we'll do that.
To move on.
So, Amani,
Item 3 for orders.
Well, notifies directed.
Yes.
May I please, your lordship. Lordship, in the last order, the lordship had directed the respondent 7 to bring in record the sketch and case diaries and all other relevant documents. So they have not submitted yet.
Well, the lordship has directed para 7. The authority is directed to directed that the production materials should not be limited. Kindly see paragraph 6. The SP Jorhat is directed to ensure that all relevant materials, including case diaries relevant to the following cases being Titapur PS case number so and so and Jorhat PS case number so and so be produced, including all other materials which are relevant to the inquiry about the circumstances under which the deceased so and so has been examined by the police and his subsequent death. The said authority is also directed that the production materials would not be limited to the requirement contained in this order, but the said authority is expected to exercise its own due diligence to produce all the materials which are required for the court to examine the circumstances. There is, but I have all the records. I have the case diary of both the cases, the Jorhat case number 555 of 2023. This case is investigated by the NIA. I have the case diary from the NIA. And the Titapur PS case number 132 of 2023, I have the case. And along with the other materials, everything I have. And this case diary is for Honorable Court's perusal, the CCTV footage and all everything are there. And I'm pressing it. But for the submission made by my learned friend that these are to be brought on record, not in the by way of an affidavit, it is possibly not the direction of the government.
Just examine it.
Lordship.
Lordship, well, on the last date, Lordship had asked me to remind
Yes, yes.
what that case diary should be given to me or not.
No, that we took it, we have consulted the law on the matter. Because once it's a case diary, then under the requirements of the present DNS otherwise and the CRPC, the accused will not be, the other side will not be able to look into the case diary.
172 CRPC deals with the accused and his agents, not me. I am an informant in this case and a
But he will
petitioner.
not be having
I may be
access
allowed
to
to look in the records.
But the
No,
time
he is
we
the
are not
informant.
allowed access.
He's the informant.
Lordship had suggested that an amicus query may be.
We'll see that. That's why first we'll have to
Let-
satisfy
let-
ourselves.
let-
Then we'll.
He's the informant, my lord. Malad, kindly take up the NIA case diary first. The blue case diary, my lord. Page number 95 onwards. Malad,
Just a moment.
Lordship,
Just a moment. Once go through it, then we'll take your.
Lordship.
what is the date on which he was taken and thereafter he committed suicide? What is, or he was hanged, he was found hanging? Where is that? Which date is that?
But he was,
26th December, he committed
Which is
suicide.
the date when he was taken and thereafter he was found hanging?
First, he was taken on 22nd, again on 23rd, again on 24th,
22nd of which month?
December 2023.
22nd.
Yes, he was taken into custody for 4 continuous days. However, he was asked to come to Madhapur police outpost on 28th of December, but he was let go home after 2 years of interrogation.
page number 95 missing. Well, this is the list of the documents available in the file.
What the learned GA was saying about the medical MLC, when the victim was dropped back at home, he was always given a tube of ointment. For the tube of ointment, which was supposed to be used on the injuries. I have annexed the photograph to the petition. And the victim was given 2 days medical advice slip for 2 days. That was on 23rd and 24th. No, Lordship may kindly see the name on the medical advice slip. One is written as Dipankar Das on 23rd and Dipankar Gogoi on 24th. So there is a mismatch of name. And on 24th, the time was given as 7:28 p.m. Though on that day, he was dropped back at home after midnight. So there's a unaccounted time for from 7:28 PM to after midnight, say about 2:30 AM on 25th. I was not given medical advice slip on 25th. So those medical advice slip may be a creation of aftermath. Also in the second FR, the IO had stated that while he was climbing the tree in order to tie the rope, he fell down from the tree and the bruises may have occurred by that falling. And also a new story has been planted that, may I kindly read the paragraph? Further, Inspector Lakshman Kumar Das, OC Titabar, had revealed the fact that on 24th, 12, 2023 at 1:15 AM, though he was at that point of time in the custody, had reported to him through the mobile phone. His mobile was seized on the first day of custody only. So how could he call the OC when while in the custody using his own phone?
Mobile phone of the mother, it is available in the GD. CDR of the mother is there.
So one accused has been arrested, taken into custody, and he was allowed to keep his mobile phone.
That's not.
Medical advice slip is at page 41 of the petition. Page 41, annexure P2.
In the process, you have lost some respect from the court.
Wrongly informed. Actually, he also did the Osnomic shoe in one of my juniors earlier.
Whoever we may be any XYZ, but I'm not mine. But to name a living person as dead, and that too a respectable senior counsel. And you don't know the profound respect we have for him, for many reasons. Number one, he was one of the very good law lecturers in the BRM Law College. Many of the Guwahati law graduates would be his student. Many. Unlimited numbers of others would be his student. Number two, he's an authority on civil side. Many things I have learned on the civil side. He is one of the mentors. And thirdly, he is one of the finest gentlemen I have otherwise seen. Not in the court. Everybody may be a gentleman. But outside the court, he is a perfect gentleman. Fourthly, he's an authority on election laws. And you have opposed him. How could you have told? You have appeared in a case where he was there in an election matter. He is an authority on the point. The fifth is he's one of the youngest law officer of the country when he was the assistant solicitor general of India. And two of the sitting judges in this court were his chambermaids. Two of them, not to speak of one. And the court to whom we are addressed, he is also very closely associated with the said learned senior counsel. We have a standing relationship. We also have relationship. You see, it's not a relationship in family, but relationship is the relationship we have in the bar, in the bench.
The lawyer who died, he is also one. So that's why I'm misunderstanding seriously too.
I don't have his name all. Something unpardonable. Yes.
Yes. We wanted that the present petitioner with the husband of the declared foreigner, he was already in detention camp for 3 years. So in view of the order of the honorable Supreme
Oh, yeah. In this matter, you said that AG would be addressing us
Yes, ma'am. We have filed an affidavit in this case, ma'am.
in this case.
Yes, ma'am.
But in those other matters also, AG was to address us.
Yes, yes.
You would be available now.
My lord, in that case, my lord, can it be fixed tomorrow? Because another item number 19 also. That is,
So we'll, if you're ready with the matter, we'll take it up. But in the morning, you made a prayer that
yes, my lord.
AG would be appearing. This time I'm asking.
Yes, AG is willing to appear in this case, madam.
Hmm?
AG is ready to, AG will appear in this cases, madam, to read petition criminal.
Hmm.
So can it be fixed tomorrow or Wednesday? If it is,
Just ask him of the convenience, then tell us.
he can appear tomorrow or on Wednesday.
Till 6, because tomorrow we have some work assigned to me. Maybe
Wednesday,
early.
then Wednesday.
6th. Yeah.
But in those cases, we have taken time because we are not sharp copy, man. In other cases, item number,
Yes.
yes,
You are to be, you are not served.
yes, we are not sharp copy. In fact, madam, this is, we are facing problem. Because while filing the case also, we are not sharp copy. No, neither the extra copy, no different.
Okay, in this case, you have got copies, you have
Yes.
already filed affidavit. In this case, you have filed an affidavit. You have
Yes,
received
in this
copies.
case, we have filed it.
Okay. All sides are duly represented. All sides are duly represented. Mr. J. Pang, learned standing counsel for the FD matters has submitted that this will be, I think, the learned advocate general will be addressing court in this, in the matter. Accordingly, on his prayer, accordingly on his prayer, the matter stands adjourned today. List again on 28, 6/8/2025. Mr. Fang, since you have made a request, we are not issuing a notice to the
Yes,
Advocate
yes.
General
Yes, ma'am.
because you have already
Yes,
picked that.
item 19, 20, 21 also, madam. All these matters may be there.
19, madam, I was supposed to furnish the instructions, madam. I have,
Please.
yes, this is the instruction I have. Oh, hold on.
Three.
No, just a minute. Let him call one by one so that we don't miss it. This is, we are fixing it on Wednesday.
Item 4, madam.
Item 19.
This matter may also come on Monday to Wednesday because
But we will also. But where is the person has been kept here unknown till today? The whoever asked to meet the information.
today morning we'll submit it. Instruction?
We had passed some orders and then we were told that the Attorney General will appear in the matter.
Yes, in this case.
This was the matter we have dictated.
Yes, ma'am.
In
this-
petition, where is the person?
No, it is the, I have furnished, today morning we have furnished.
No, he's
it.
in the Assam, the 7th Assam Police Battalion.
Yes.
Sorry, sir.
He's there.
You have not been informed.
Yes, we informed, he was there.
He was
We
there.
told
Yes,
you.
He was there. His junior was there.
In the morning we informed, we passed an order, but then we were told that.
It is a person.
The battalion director.
Then
Managing-
will be allowed to meet him.
Even that hasn't passed. Even that order hasn't passed.
No, we had passed this order, but then we were told that the Advocate General will appear. That's why we stopped.
Oh.
We'll permit him to, in the
Yes,
meantime, go there.
In the meantime, let them appear.
Okay.
Submit the copy.
In the morning we said, where did we stop in the morning?
Item 90.
To visit. To visit the, visit the, from Tamil to the holding center, same order, holding center visitation, right? And then take signature in the Vakaratma.
Madam, in this case, madam, they have approached honorable apex court also.
No, that's okay.
Yes.
This is a right, you may have Vakaratma and do whatever it is. Next. At this juncture, the done at standing question for the FD matters is submitted that in this matter, the Advocate General make his submissions. Next, accordingly. This is matter on, same,
Six.
we are giving you visitation right with one family room. Next, before that, let's see. The instructions received by the, by Mr. M.R. Adhikari, Commandant at CEC, is returned, which may be produced on the next date of.
Three persons. Three persons.
Pardon me,
3 persons may meet him.
one, the petitioner and one person.
What happened in this case, my lord, your lordship may have seen the instruction, my lord. He was sent back, he has come back again, my lord.
No, that's okay.
Like this, naturally. No, it's not, no. Yes, of course, and it come back again.
Item 20,
Item 20.
Here also, madam, I have received instructions, madam, the person, the Amita Begum, madam, the wife of the petitioner, she has not been handed over to us. She has not been handed over to us.
20, 21, 22, 23, my lord. All these cases, I have not been served copy, my lord. Today morning, we have mentioned it. So, my lord, the,
Ahmed was here in the morning.
yes, he was
He
there,
was
my
here.
lord. We have taken that, probably he thought that it is already over, my lord.
Okay.
So he will,
All sides are
yes, you
represented.
he will serve copy.
All sides are represented. Mr. M.R. Adhikari, done at CGC has submitted that he is in receipt of instructions. Next. Mr. In the morning, when we were passing the order, Mr. Verma was there.
Yes, yes,
Will record his name?
yes.
Is A. Verma, done at standing for the FT matters, has submitted that despite order dated 28/7/2025, extra copies of the writ petition within bracket, one soft and one hard copy of the receipt. That's, that has not been served. For which she could not obtain the requisite instructions. Next one. The learned counsel for the petitioner shall take note that the extra copies of the petition is not served. In terms of direction issued on 28/7/2025, adverse orders would follow. Next paragraph, based on
Sixth,
same 6/8/2025. This order will be in item 20,
21, 22, 23.
same one, and 23, and 23.
My only prayer would be, Malad, since I have received instructions, Malad, I will be given liberty to, Malad, produce it on the next day.
You said, is the, this Amadhika is in receipt of instructions, huh? There you add. He is requested to retain the instructions and to produce it on the next day. Fine.
Supply item 24 with 25 for orders.
That money, my lord, 2 lakh money already sanctioned by the, I received. By finance department already sanctioned. And they have done the political department. It is like a amount. Have you? No, this is finance department, political department, political department. No, political. Finance for good. All of that. Okay, two extra didn't, and symptom to which 2 lakh. If you put amount to place section relief, it is same earliest within by the court order. It is.
It is good that the authorities have taken a decision.
Yes.
When should we keep it so that the petitioner may get the compensation by then? How much time? When should we list it again?
My daughter.
Mr. Mahmood, they have passed an order to give you the news.
Yes, that's 2 weeks, sir.
We'll post the matter after the Independence Day.
Yes.
By
sir.
then you have 3 weeks' time.
The way.
Please comply with the order.
After 4 weeks. sir. amount 2 lakh. Yes. So already they will release the amount, already mentioned already. Political department already released. In the meantime, my lord, that amount will be. They was already sanctioned that amount. The department, finance department already sanctioned, rupees 2 lakh. Yes.
Upgraded item 11. Upgraded item 18. Item 18.
Right. Lordship is 32 is the opinion, but started from +12. May I draw your lordship attention to this 34 your lordship of the opinion. So I have exhibited as many as 9 documents. Substantive nature. Petitioner is in the detention camp in the bench. 2012-2020. Case number 7, state paragraph 2. Custody of 2012-2020. 24. Right around 80 years to people in the town. 16. And so far the information derived in the health is also not working well, but Yes, 39 is the voter list of 1971. Father's name is Kazimuddin, serial number 605. Mother name is Sodarzan. And the name of the petitioner is 608 serial, Tahed Ali. So,
What is the first, what is the year in which your name appeared first in the voters list?
first in the voter lordship, this is 1971 in lordship, there's 39 people. 608 serial. Translation of
1971.
1971.
What is his name?
His name is Tahed Ali. Tahed Ali alias Tahed Ali. Tahed Ali, son of Kazimuddin. So age that time indicated you lost 27. And so far they considered this the first time that he did get in the portal service. And thereafter we lost 1985 also. He got case 42. That time father died from mental illness, he died because 1985 father died. Quiet. So his name appear with mother, Sodarzan, Tahed Ali. Serial number 750. That's 40. Then you lost it. 1989 also.
Just a moment.
For details, your lordship.
Just now, man. Well, just to go for the man. Because I don't know what the tribunal did, but the arithmetic is incorrect. You have a pen, we'll give you the arithmetic. Please come to the voter list. Of 1971 is at page 38. Correct. You have a piece of paper?
Yes, sir.
Please write 1971 minus 27. Year is 1944.
Yes.
There will be year of birth is 1944. Correct.
Yes, sir.
Now, come to the evidence of the petitioner. Which page is that evidence?
Lordship, just 21,
21. He is 72 years in 2016, page 21.
Yes. 72, mother.
Correct. So 2016 minus 72 is again 1944.
Yes.
Correct.
Yes.
Now please come to the school certificate. Which page is that?
Okay.
Hmm? 57. Correct.
Yes.
So this is 1952 or 62?
60,
It will be 62.
62, particular at page 52.
62.
Yes.
So if it is in 62, he is 9 years.
9 more.
63.
The year of
of 63, he is 9 years.
Hmm?
As per the school register, he is 9 years on,
This is 52, not 62.
no, no.
Is it 62 or 50?
Particular page 50.
Madam, right below, your lordship may kindly see the page 58 in the last line, madam.
Just now.
Page 58, last line, it is.
Just now. Because the two calculation we have seen from the two documents, it is, his age is consistent.
Yeah.
In the school certificate, it is different.
School
And in the
certificate.
affidavit is given it different, but the name of the father and the village is same.
Right from the very beginning, there's no shifting. There's no shifting. And yeah.
But with the age you are giving, you become an adult, and therefore it is disconnected. You become a major then.
So you lost it. So for the certificate is concerned, you lost it.
So your affidavit is also there,
Lost
says
it.
62,
Lost it. If you counted the certificate, then there is some discrepancy.
then it's a substitution of persons.
Because you lost it,
A 9-year child becomes a 18-year, 19-year-old child. Okay, so
that time you lost it, thinking from, suppose you lost it, other documents as well as you lost it, the oral evidence.
no, but that is not your case. That is not your case here in this writ petition. And the difficulty is that although, except for that discrepancy, but I don't think the school headmaster has come and deposed,
That's correct.
then
That's correct.
will not be able to help you.
So therefore you lost it. So that, if that was not done, also would have been, would have done, you lost.
because the school.
But in this declaration, that is not your pleaded case.
Therefore, you lost it. And also, you lost it, some other documents are also there. So if I.
No, you know, you see, Mr. Devan, you have done more cases than we have heard. You have more experience than us. Can in statutory we can express our opinion? You have to find out faults, and to that effect, he has no pleading in your petition. Even if we omit this, then your evidence on affidavit hits you. There you have stated you are 62 school pass. And if the headmaster does not come, then this school certificate goes. Your evidence is wiped off. And in the land document,
49.
we are unable to connect. The reason is the name of one's Samed Ali appears, Shahid Ali appears in the Jamabandi. But the problem is that you see the Pata number is 279. Correct. Now, please come to this document at page, which is Exhibit C.
Land revenue receipt.
Yes, doesn't match. The Pata number or tag number doesn't match.
So for the information is derived to last year. So this land revenue receipt, so this is the land revenue last year. It's a bunch of more dictionary hours. Key part. Because someone wants to perform that. Others know for the copy. It's 279, and I specifically with some query last week, found that it's some other having or some other land.
No, but we can do that of the day.
This statement is really different. Earlier operation, you left it for the certified for your instance, and that's valid. Government is certified for it.
Pass it on.
Yes, it's revenue. Revenue. Never care. I don't have this. It's clear for me. I have the copy.
Yes, please pass it on. Both the documents, please pass it on.
This one is a lordship, again, the land revenue receipt is different, your lordship. And therefore, they inform that some other lands are also there, but
Because, Mr. Devan, we are not satisfied with the evidence which is available before us. We'll tell you in sequence. Come to page 34.
Okay, 34.
34 is the Jamabandi. Exhibit A is Jamabandi. Now, this Jamabandi, you know how it destroys your, how does this document destroy your case? Have you seen that? No. Have you examined whether this document helps you or destroys your case? No. This Jamabandi is at page 49. The Jamabandi is of the year 1968 to, 58 to 65. Correct, 7 years Jamabandi. Come to page 51. Your name is entered by an order of the authorities of 23 to 1996. Therefore, it's a post 25/3/1971 document. And therefore, this doesn't help you. It doesn't show your presence in India before 1971. And then rest of the document, I don't have to tell you. No, you see, we are not on specifics, who died, who is alive. We are trying to tell you that exhibit 1A does not help you. If exhibit A does not help you, you look at your own other exhibits and then you'll come to know you have more experience than us. For every 10 cases I have dealt with in the bench, you have done 100.
Lordship, I'm 80 years old at the 11th hour.
That's okay.
How long I will have.
No, that's okay.
And also, so far, the definitive health is not working.
We don't know. We have had history of people of 134 years. A few days back, somebody died, 134 years.
And also.
No, not more.
And other, you will say, any other family members are not. Not a single member of the family members are.
No, that we don't know.
But here, this case with the.
That we don't know.
Denying the fact of.
None of the other documents help you.
Supporting the.
None of the documents help you. If this document goes, every document is a post 71 document.
But my humble submission before you lost is that if one son is given to me, but I try my best. I'm 80 years of age, yes, you lot. And therefore, otherwise I'm not insisted you lot. Had he been you lost it 65 years old, have been different you lost it. Because in every time this man is. So you lost it one son, I can't think when, and since long 8 months I'm behind you lost it, and this can. So. And also my this other sons and sons, they are also working some other places.
You see the difficulty. I am saying it in a writer note, not very serious about it, but I'll tell you something in the writer note. 2 days back, there was a oath-taking ceremony. Were you there? No. No, it's okay. I'm not asking a question why you were not there, but you are not there. Had you been there, you would have known we take oath to uphold the constitution and the laws. We have not taken an oath that I will do as whatever my wish is. And incidentally, listen, incidentally, you will find in this reference many counsel, including Mr. Chaudhary here, whoever are in criminal side of practice, they will never be seen.
So far, you lost the documents.
No, I'm not targeting you. I am not targeting you. But I'm just telling you. Nothing adverse against you, but
These documents are constant, it's not helping, you lost it. But you lost it.
okay,
All-
we'll consider
all-
your submission. Yes, Mr. Pang. But
All
you-
human beings are fallible, you lost it. And all human beings are fallible. That's why even while writing, even the school certificate and government copy. And it's apparent in many of the cases, these types of you lost it. It's evident. It's not generalized, I'm not generalizing.
Well, it's nothing to see, your lordship has already pointed out. The document which my learned man has relied, that contradict themselves, himself contradicted, even the evidence WS has stated the same thing. Same thing is stated, it contradicts it. His own case, man. Secondly, the brother who was there to depose on behalf of the petitioner, he was not introduced in the matter WS. That he has a brother in the name of so and so. The brother is also not introduced in the WS. He has suddenly appeared, but he has given an evidence. He also stated, my lord, the school certificate, about the school certificate, that he passed class 3 in 1962. My lord, that is his statement as well.
But now I cannot develop in that.
So-
Statement, the foundation lost.
Apart from that, my lord,
The 226 you lost it, of them.
that's why the jurisdiction under my lord, this, that's why I would like to. As your lordship knows, my lord, we have numbers of judgment of this noble court, whereby it is said, my lord, the reasonable court under certiorari jurisdiction may not look into the fact of the matter tribunal, because the fact has to be decided by the tribunal. Your lordship has to look, my lord, whether there is error apparent or whether no, my lord, natural justice was provided with the petitioner. Otherwise, your lordship may not interfere the opinion of the tribunal on fact. That is the honorable court has decided the numbers of cases. In fact, the By the para 112 of the Muslim Mandal. How we do family law. So that's family law. We can be quite often. Not for the things that it is allowed to later for few days it may come, but so, well, the only point, I would like to refer this, there are 112 of the Muslim Mandal case. Yes. 2013 1 GLT 809. The jurisdiction of this court has been, because this is a development by the court only. But the tribunal system in itself, the foreigners tribunal system, after the foreigners tribunal order 1964 is brought into the what will be the procedure that is not provided adequate. So this is by the court, this honorable court, time to time pass several orders. And on that basis only this honorable court is everything is working. So in para 112, what will be the function of this honorable court under 226? That has been totally described. Everything is described. What will be the jurisdiction of this high court while dealing with the opinion of the tribunal?
Here, Lordship has called for a report. That report in cell cover has come. He wrote it. He wrote it. He wrote it. the report is in seal cover, the witnesses, will witnesses, whatever logic was indicated in the order, they were produced. The last two witnesses, they appeared on 8/3/25. Oh. Okay. report to आपका fill करा था। I have received the record. In the record, But this is the second copy, the forwarding to the forensic and the reports subsequent to the reports. Same bunch, 2 bunch. Thank you. Hello. 2%. The, this report I have not seen. This was, this was in the sale order. Okay. If you take a look. Mhm. What is the number? Yes, yes, yes. No, no. Logic.
In this crossfire, 2% with electric jackets.
Okay.
Any injury to any other person with
Logic. The, yes, well, some injuries are there with the, of the police persons also. But in the bunch I have given, the reports are there. What has happened, Malad? The vehicles were moving and these persons, they were arrested, accused persons in the inside the vehicle. Malad, there was an ambush when they were crossing the forest. And immediately, Malad, the police persons, they came, got down from the vehicle. They could not because they were handcuffed, under handcuff in the vehicle. And Lord, the other persons, they get down and they took position and there was crossfire.
these 2% were sitting ducks in the vehicle, the only target?
No, the entire two vehicles, entire two vehicles, two vehicles are there. In the police team was targeted, Lord, from jungle, from both sides.
Your prayer. Two people have now. And two others. Others had appeared, approached this court, reached to the secret court when, 2 days after the killing, when they approached the secret commission, they also received a summons from the same higher under whose supervision people were killed. To receive the summons to appear time. So this such matter will be appeared Supreme Court by filing a petition to minutes. And where is the figure told to put the company cycle. But at the same time, we're given as an interim relief that no potential still fine is not be taken. That in that matter, we have to. That at this time of our prayer, one was of course to have an impartial inquiry. What is second was that the CFIO who is an accused, at least now the investigation is going on. It's an accused in a case. Otherwise, there are two people paid other so that they cannot suspension in certain methods so that they cannot manipulate the things. But here in the CFIO component in the case, and first who has
also someone has said that time, because of the history of the project is not good. Recently, for the prospect of application has come at people before the SCF decided. I'm just privy to those documents. So after those patterns, actually. You consider purchase inquiries. You want the protection for the IO village. Yes. That's been responsible for the death of any other. I think compensation. One would. Asking for your bank statement. If he still not in the first 50, you provide or a plan. They've indicated some of them can be. It's the wife of, not the petitioner, but the wife of the person. It has a copy of.
Lordship.
Do you have any, does the state government, last time also I said to someone, does the state government has any protocol, this report has come? This report must be submitted to whom?
This report is one of the, I think it under 176 of the CRPC.
So what is to be done?
I have asked the concerned police officer. They said that they will apply for a copy if the report is given, and they will collect the copy and give me if the report is done. Because the magistrate inquiry report is already in the bunch. That was done by the executive magistrate, the ADC. And this is under 176, my lord. I'll just check up. Because as per my conversation, my lord, they said that they will, if the report is ready, they will apply and they will get a copy. But what is the procedure? I'll inquire.
Is it already clear?
Otherwise, my lord,
We're just asking you this, report under 176(1)(a) CRPC, which is made by the judicial magistrate or by the magistrate, executive magistrate by an inquiry. To whom it is required to be submitted, are you aware of it? No. CRPC doesn't say anything.
what activity taken off?
No, actually, it's second, third part.
Yeah.
First is the report is there. The report must go to whom? Who is the authority to have the report? Number two, how is the authority required to deal with that report? And who is the authority who will ultimately take a decision? We want the entire chain. This is what we want. Last month we said, because
Lordship.
this is one of the reasons
In the
we wanted to go through it and then satisfy ourselves.
Lordship, in
We
the
have
other, in
also
the other
heard-
case, once,
The learned counsel for the petitioner for disclosing for that, the nature of prayer he is now making. You keep it in mind, then
Lordship,
take it.
that information I don't have, whether why the bank account details has been asked, I don't know about that information.
It's okay, whatever be,
Lordship.
that is not the major issue. The
No.
issue is that this report comes. Who deals with this report and the government? We'll try to see it also, what it can be done.
Yes, sir. I'll also inquire.
So the outside they represented. Pursuant to the orders passed earlier. The Learned District and Sessions Judge, Koprajhar, by a forwarding letter dated 17/7/2025. By a letter has forwarded the detailed report of the judicial inquiry received from the Sub-Divisional Judicial Magistrate within bracket M, bracket Gosaigaon. Go to the perusal of the said report to consume some time, so accordingly, list this matter again on Monday, 4/8/2025. Yes. You just speak. First. And
But these are records I have received, this contains one of the inquest report, PM report, and all documents are there. FSL report and all these documents. But
say that
I'll,
the Lawrence Senior Government Advocate has also produced a bunch of documents containing the FIR, copy of the FIR. Postmortem report, seizure lists, inquest report, etc. Forming part of the case diary. Said control documents are kept on record.
But you kindly allow me both the copies for 5 minutes. I'll just paginate and I'll paginate and submit. Pagination I cannot do.
This
I'll
one?
paginate and both the copies, same copies, only 2 copies I have given.
Okay.
Lot.
Okay.
Lot.
Have it in our chamber and then both way.
Lot. API कहाँ करोगी? API Very fine. Very good. Good. Maybe. Yes. Logic. But if not inconvenient, can it be on 6th? Wednesday. Look. We'll see. Logic. Oh, outlet. And it's it's a long pending case, that's when. Yes. Other one, my lord, not the earlier one, lordship took up, my lord, this is another matter, my lord. So here there was one case lost by the petitioner, my lord, other FI lost by the police authority. So, my lord, and both the case ended in FR, my lord. There are others also here before this only said that, but possibly, my lord, both the records might be required, so.
On previous operation, what we want directly.
No, this is another matter. It was actually at last of the load, see.
On direction is given to police FIR number along with the in connection with somebody here, case number. We have received the FIR number also.
No, those are other matters. Other matters. Similar nature. Yes, Srirangani. $67, but. One is my lord, that is 67, my lord. My lord, 67.
Now, in this case, you see this document,
FR.
if FR is accepted, that means you have accepted the FR.
My lord, that instruction was called for, my lord, whether, my lord, it was served upon the informant or not. But if it is there, my lord, that I don't need to
Like
do.
this,
Accepted, if after notice and everything or not.
we don't know that.
That
usually.
instruction was called for, my lord. So, lordship, kindly have a look at page, at that order dated 31/20/24, my lord.
30?
31/24, my lord, because these,
January.
my lord, 31/20. Because we submitted on to whether that DGP so and so
Whether it
shall-
was communicated.
yes, my lord. Because, my lord.
To inform for the,
Records also,
that will call for the scan copy of the record.
yes, but that would suffice. But well, long pending case, that's why we have to try and get it. If it is from the honorable court, madam, because kindly see, madam, here. The judge, madam. That is from a judgment, madam, Balwant Singh, madam. Provision possibly, madam, in the CRPC possibly, madam, it is not there because of the judgment of the honorable. Possibly, madam, possibly because of the judgment, Balwant Singh and madam. That is 1985, madam, 2 SCC 537. Your law developed from that possibly. Bhagwan Singh. I have the copy if you like. Lordship, page 542, not the time. Last paragraph. Page 542. And phone numbers are also, madam. I'll try, but. Yes, ma'am. Okay, clear? Definite? Yes. Yes. No. Reply is not there, yes, ma'am. Here, my lord. Here, my lord, here, possibly, my lord, with my limited understanding, my lord, here, if the records comes, my lord, and because if the investigation has been done in a proper manner, then we have no taking. So that aspect would be clear from only from the manner of investigation and the diaries and everything that will be there. But if accepted, madam, yes, yes, then my lord, definitely there will be a different view. Yes, yes, my lord, my lord. That, yes, yes, that is true, ma'am. If possible. Yes, yes, definitely. My lord. Not present.
Four to nine. 4 to 9. Okay.
One fifty. 120.
Status of the final report. In respect of Amburi Police Station, case number 66/2013 and 67/2013. And as to whether the informant of those cases were communicated regarding submission of final reports.
Possibly the BMS, it has been incorporated, possibly. I- That notice, but.
Next one. The London Government Advocate has produced a copy of instructions dated 15/2/2024 submitted by the Superintendent of Police of Chiran Katilgaon that the Court of London Subdivisional Judicial Magistrate within bracket M bracket was Bijli had accepted the FR petitions in both the cases. FR in Amguri PS case number 66 of 2015 was accepted on 24/6/2016, and FR in Amguri PS case number 67 of 2013 was accepted on 15/6/2017. Next. According. As there is no report as to whether the filing of the final report was communicated to the complainants, or the court is inclined to direct the learned sub-divisional judicial magistrate within bracket M, bracket to HD. Send a scan copy of the records relating to Amburi PS case number 66 of 2013 and Amburi PS case number 67 of 2015. Next. That requisition along with the download copy of this order to send to the scan copy of the order to send the Court of Learned Subdivision Judicial Magistrate completely. The copy thereof. To the Learned Chief Judicial Magistrate, Chirang or Kajal Bab. For info. Next one. Simple. This is my email. Next one. This on 20 August 2025. Can the requisition shall be sent by email. We convert it to the settler court to send a scan copy of the record by email to be placed before it. This one. So that copy of instruction, copy of instruction, they have 15 to 24. It depend on the part.
In the BNS, the BNS it is there now. In the BNSs it is there.
188. I think it is not there still.
No, 193, my lord, 3. Roman 3 possibly, that would possibly matter.
193.
193, 3. Such a Roman 3, the officers shall communicate. That is possibly whose information is it?
No, this is officer shall communicate
Yes,
to the authorities. This is not to the complainant.
yes, sir.
It says communicate in the manner the state government by rules provide or action taken by him to the person, if any, by whom the information related to commission of office was first given. So these rules
First-
have not come.
Not informant, not first person who. Maybe like your first person who stated about
The
the information
information
of
who is the first
office.
informant, but still the rules is not there. Shall communicate in a manner as the state government is by rules modified.
Because those judgments only possible.
Hmm?
Because of those judgments.
Ah.
Okay, my lord, that notice it, law developed to that extent.
Hmm?
Law developed to that extent because of the fairness
Okay,
of the procedure.
we now get it. I assume that the same provision is there in the CRPC also.
No,
But the exact thing, it's of the forms
inform.
the first person who is.
Yes. Yes.
So we just said.
Yes. Yes,
That is not there.
but this is from the judgments only, madam. Yes,
But with the CRPC also it's there.
yes. What I meant is that, my lord, if the notice are given by the police also, that would not suffice. There are judgment, that was one. It has to be to the informant from the court. Subsequent, there are three judgment on that way.
Just add one more thing that this scan copy. It is very clear that the scan copies are required. So as to ascertain as to whether before acceptance of the FIR, notices were sent to the first informant of the complainant. Before its acceptance by the said learned firm. They will now understand what we are wanting.